Well, good evening, everyone, and welcome back to AJ103 Criminal Evidence Online. Tonight's lecture is going to be on Chapter 12, and we're going to be looking at field interviews, arrest, and jail searches. Now, as with some of the other chapters, please keep in mind that there is a lot of information that we need to cover in this chapter, so do yourself a favor and read the chapter as well in the textbook, along with focusing in on all of the examples that they give in each one of the sections, because this information will really help you, again, add context to the discussion. And then don't forget the student resources like the key terms or the discussion questions. So because we have so much to cover, let's go ahead and jump right in and look at our featured case for the week. So in early 2012, George Zimmerman shot Trayvon Martin. And Zimmerman, a neighborhood watch participant, claimed that it was self-defense. And police officers were split on whether Zimmerman's act constituted a homicide. Now, eventually, Zimmerman was charged, and central to Zimmerman's defense is a law that's called the Stand Your Ground Law in Florida. Now, I'm going to have you, of course, read the case as we ask ourselves these questions that we're going to talk about. But this was a pretty high-profile case. So after you read it, ask yourself these questions. Well, hey, should Zimmerman have to prove that he acted in conformity with that law, that stand your ground law? Or should the prosecutor have to show he didn't? And who should make the decision to arrest in these types of cases? And when should such decisions be reviewed? So after you read the case a little more, you'll understand the relevancy, if you will, of the question. So what do we hope to learn? Well, first, to explain what constitutes a lawful arrest, and understand the right of this term stop and frisk, and this is very controversial as well. Explain how lawful searches are made or done, and show the limits to lawful searches after arrest. So after we arrest somebody, can we search? And if we can, what are the limitations? And understand the different types of searches, because there are quite a few different types out there. And also explain when warrantless searches are in fact permissible. So here's a couple of myths and facts that are out there. So we'll go through a couple of these. If a fleeing felon fails to stop when told to do so, police officers can shoot. Well, yeah, a long time ago, many decades ago, sure, that was something that was written into some states' laws. Well, now the facts have changed, and specifically because of the Tennessee versus Garner case that you'll hear a little bit more about later, you can only do this if there is what they call imminent danger. How about an officer is allowed to do whatever is necessary to prevent the destruction of evidence? Well, no, we can't use methods that cause undue pain or in other ways shock the conscience of the court, if you will. How about police may not detain a person unless there's probable cause? Well, that's not true either. All you really need a lower standard, but you do need a standard, and that would be what they call reasonable suspicion. And a lot of people get these terms mixed up. Everybody thinks that an officer has to have probable cause to stop you for a traffic stop, and that's not true either. All you need is reasonable suspicion. Probable cause is a step or a level higher, and we'll talk about that. How about the police have the right to automatically frisk anybody that they stop? Well, no, you still have to have reasonable suspicion that the person is armed. Police need an arrest warrant to make an arrest for a crime that was not committed in their presence. Well, that's not true either, because probable cause to make an arrest in California is all you need. And that's the higher level above reasonable suspicion. And then finally, when there's no emergency, police are required to obtain an arrest warrant. Well, this is only applicable if it's in somebody's house. And we'll talk more about some of these as we get deeper into the lecture. So we're going to start with a little bit of the right to use force. Now, I have a lot of things to talk about, so bear with me. The Fourth Amendment places boundaries on the rights of police officers to stop individuals. And a lot of this chapter is going to focus on stops based on two different things, like reasonable suspicion or probable cause, and we'll define those. And inherent in the right to detain someone is the right to use reasonable force to do that. And every time the police are allowed to detain someone, officers are also given the right to conduct at least a limited search if the circumstances indicate that it's needed for their safety or their protection. Now, the rights of the police vary according to the reasons for the detention. And three types of situations cover most police encounters. And these are what we call field interviews, arrests, and booking. So again, these three types of situations cover most police encounters. And searches of jails and prison inmates we're going to talk about a little bit later. Well, so anytime an officer has the right to detain someone, the officer has the right to use reasonable force, as I said, to prevent that person from leaving. And this applies to temporary detentions for questioning and arrests. Now, of course, the force must always be reasonable under the circumstances. And deadly force is justified only when a life, including the officer's life, is in danger. Now, the Supreme Court set this standard in a very significant precedent case, Tennessee versus Garner, a case that dealt with the right to use deadly force to make an arrest. Now, the justification for the use of force is even less when the officers are only investigating to determine if a crime occurred. And only a situation perceived as life-threatening will ever justify using deadly force. Now, George Zimmerman, because he was not a police officer, was not subjected to this rule because he was a private person. And if you read the case, you kind of know where I'm coming from. And Florida had the right to enact the less stringent stand your ground law, but it must also utilize the constitutional standard for police officers. Now, the Fourth Amendment also controls the right to use less than lethal force. And as the court pointed out in another case, Graham versus Connor, when force is used, it must be reasonable under the circumstances. Does that make sense? And although the rules on the use of force can be reduced to a kind of a short list, the rapidly changing situations that police officers face dictate that officers be well trained on the issues involved before they have to make these split-second judgment calls on whether to shoot or not. So, what should be considered before using force? Well, some of the factors that must be considered when using force will be what the reasonable person is, reasonable appearance, and what they call reasonable force. And factors that should never be considered will be getting even, revenge, retaliation, or hey, I'm going to teach them a lesson. And then kind of back to the detention of individuals or the different types. So the Fourth Amendment places boundaries on the rights of police officers to stop people. And these are listed in three different areas, and we're going to touch on them real quick. So the first is a consensual encounter where you don't really need any legal rationale to stop somebody because it's consensual. They are free to leave. And the next level up would be reasonable suspicion, where the officer might believe that there is some type of criminal activity taking place and that you might be involved in it, and you're going to investigate a little bit further. And then the final one is what we call probable cause. And this level is needed to search an individual or seize an individual, which means arrest them. So when we talk about the boundaries of the rights of police to stop individuals, these three terms will come into play. Now, as we mentioned a minute ago, anytime an officer has the right to detain someone, the officer has the right to use reasonable force to basically prevent that person from leaving. And this applies to temporary detentions for questioning and investigation, and also arrest. Now, as we heard, the force must be reasonable to effect the arrest or the detention, and the force should be what they call proportional to the threat that's being faced. And deadly force is restricted, as I've talked about, in its use. And non-deadly force is also limited, but has fewer restrictions than deadly force, and you can probably understand why. So now, what are the factors that we should consider when we talk about this using physical force? What are some things that we should look at? Well, the person, the appearance, and the force used. And again, a couple of these precedent Supreme Court cases set the stage for a lot of things that govern use of force and search and seizure. So this case, Tennessee versus Garner. And I have at the bottom here a link to a YouTube video that goes to that's really good, you guys. That it's about 20 minutes long, and it covers this case law. And here I have some links to a couple of case summaries, but this video I would suggest that you highly watch. But let's review quickly. So police shot a suspect fleeing the scene of a burglary. Now, the police were aware that he was unarmed and he wasn't violent, and he was, again, fleeing. And as a result here, the Supreme Court placed limits on when deadly force can be used. And a fatal shooting is the ultimate seizure under the Constitution, and police should use deadly force only when the totality of the circumstances lead them to believe it's necessary. And the suspect should be what they call an immediate physical danger to the officer or another officer or innocent citizens, etc. So watch the video to get a better handle on it. And Graham versus Connor, the other case I mentioned, well, in this case, and again, I have a couple of YouTube videos for you to watch, and these are a good way to add context. Graham was a diabetic, or Graham, a diabetic, well, he was a diabetic, was arrested and sustained some injuries when police took him into custody. And he ended up suing the city and the law enforcement officer, saying that he used excessive force. Well, the court came back, and because of all these symptoms and things that the officer saw Graham doing as a result of this diabetic event, if you will, how things took place, how he acted, etc., etc., the court applied the objective reasonableness standard to all arrests, and said basically, you know what, you don't have to show that harm was intentional or malicious. So take a look at this case if you want. just again gives you a little bit more of a basis. And because we have so much, we're going to skip our questions, and you can look at these if you want at your leisure. And here finally I have a link to a YouTube video where a civil rights activist from Arizona who was really talking a pretty foul game, if you will, against law enforcement and second guessing law enforcement's actions and protesting and leading protests, etc., about the way the department was using force, etc. Well, this gentleman got invited to participate in a use of force training. And he went to the local police department and participated in this training. And when it was all said and done, he was honest enough to admit in a newscast that basically he didn't realize how hard the job was, and that he now has a new respect for law enforcement, etc. And I applaud this dude for doing this, because not everybody would have taken the time to do this. And he was also, again, honest enough to admit the difficulties when it comes to split-second decision making. So a couple of sections that I'm just going to have you look at your own will be section 834A. And this talks about when officers use force and people resist. If a person has knowledge or by the exercise of reasonable care should have known that the person is being arrested by a law enforcement officer, they are to refrain from using any type of force or resisting. And here's a section 148A that talks about anybody that does resist, delay, or obstruct police officers. So I wanted to let you know that those code sections are out there. And then finally, before we move on, and I know we're chasing little rabbits here, but that's okay. It's not a violation of a section for a person to photograph or make an audio or a video recording of an officer, because they do it all the time on cell phones. Now, back to our reasonable level of force. We talked about the three things: the person, the appearance, and the force. So let's kind of talk about them in a little bit more detail. Well, when the topic is the right to use force, the reasonable person is the reference points, and a hypothetical reasonable person has all of the physical attributes of the person who must decide whether to use force. Now, in addition, the reasonable person is in the same situation as the person in question, has the same weapons available, and the same people are present. The reasonable person will have reasonable emotional reactions to the situation. And the reasonable person is neither overly timid nor overly brave. So as to the reasonable person, it varies depending upon the suspect and the police officer. And consider these examples, and you'll get better context. A strong young policeman with a 9mm gun in his holster is being attacked by a person who's high on PCP, but the officer's backup has an estimated time of arrival of about 15 minutes. Now, the reasonable person is not an average person. The reasonable person test focuses on a strong young policeman who is armed, is assaulted by a person who is high on PCP, and has no one to assist him for 5 minutes. So you can see he clearly has the right to use reasonable force. Now, if you change the hypothetical, the same officer stops a car because of a minor traffic violation driven by some old woman who refuses to roll down her window to talk to the officer. The reasonable person analysis is applied to the same strong young policeman. However, now it considers the facts that he is confronting some old woman who really doesn't pose a threat. So no force is at this particular time is justified. Does that make sense? Well, what about as to appearance of danger? Well, when analyzing the right to use force, the facts are not as important as what the facts reasonably appear to be. In other words, if it reasonably appears that the menacing, tattooed juvenile gang member has a gun in his pocket, The reasonable person will formulate a response based on the belief the assailant has a gun. The analysis doesn't change, even if the post-mortem autopsy reveals that the tattoos were rub-on tattoos and the weapon was a water pistol. So a perception of danger may enable use of more force, even if the real danger is limited. And then what about like force itself, as to force itself? So again, a lot of ground to cover, guys. Supreme Court decisions resting on the Fourth Amendment set two limits on a police officer's right to use force. Now, first, officers may never use deadly force unless the officer's life or the life of somebody nearby is in imminent danger. And by inference, deadly force is never authorized to apprehend individuals for misdemeanors and nonviolent felonies. But the offender's actions are more important than offenses committed. Now, second, whatever force that the officer uses must be reasonable. Now, reasonable force is the level of force that a reasonable person, we've been talking about it all so far, would use to safely extricate him or herself from the situation. And if it appears the officer can talk his or her way out of the problem, then a resort to even minimal force would be reasonable. Now, reasonable force is usually a higher level of force than the assailant is using, because if both parties use the exact same thing, it'd be like a stalemate, right? And remember, these situations are usually fluid, which means they're moving, and require new analysis every time some of the facts change. So consider the situation where an officer is trying to talk an armed person into surrendering. When the gun is aimed at the officer and it appears that an emotionally distraught person is about to pull the trigger, it may be reasonable for the officer to shoot in order to save himself. And a few moments later, when the person apparently is calm and puts the gun down, the officer would not be justified in shooting. If the person retrieves the gun and starts talking about suicide, the facts have to kind of be reviewed again. And you'll see how things change. So deadly force, only if police or the public are in danger. And again, the force has to be reasonable. And I think we've kind of beat that phrase to death, reasonable, but that's what it is. So what's excessive force? Well, that's the force that is beyond what is reasonable. And that's termed excessive force. And I put in a couple of charts that are from the Riverside County Sheriff's Department that talk about the reasonable officer response, like the one you're looking at here. And again, they even put in here, the officer shall not use more force than is reasonably necessary. But they also put in the factors. And this is what's really cool about this one. For some reason, it falls right in line with the textbook. So you have the officer factors: age, training, exhaustion, the subject factors, age, severity of crime, weapons, everything that falls in there, and then environmental factors, like the weather, lighting, footing, all that other stuff. And then they talk about that objective reasonable test that we've been talking about. Would another officer placed in your situation of similar training and experience believe the level of force you used was reasonable? Well, there you have it. And then I have a couple of what they call use of force continuums, and I'll let you kind of look at those at your leisure, but I wanted to show you the first one. So how about, again, and let me just kind of finish with this part about using excessive force. So as I stated a second ago, the force that is beyond reasonable is called excessive force. And this is important, or an important distinction, because an officer can be charged with criminal conduct if he or she uses excessive force. If the excessive force results in death, the officer can be charged with manslaughter or, in some circumstances, maybe even murder. And the prosecutor determines, of course, what charges to file. But the case will be decided by who? You should know this. Going to be decided by the jury, of course, unless there's a plea bargain or something like that. And of course, expert witnesses frequently have conflicting analysis of the facts. So we've talked about use of force and what have you, and let's talk a little bit about some methods of obtaining evidence. Now there are certain boundaries imposed by our society that can't be crossed by the police. And the Supreme Court ruled that the police may not use methods that, quote, shock the conscience, unquote, of the court. So that's the phrase. And this concept is derived from the due process clause of the Fourth Amendment. And there's a couple of cases out there that we're going to look at, and one of them is Rochin versus California. And this is a landmark case in this area. Now, in this case, Rochin attempted to swallow the evidence, and the police responded by having his stomach pumped. And the court subsequently held that this procedure was very painful and could not be tolerated in a civilized society. And also, in a different case, in the Hayes versus Washington case, the use of what they call the third degree to obtain confessions is on similar footing, if you will. And due process is violated when an officer coerces somebody during an interrogation. So there's a couple of cases that are there. This is a link to that particular landmark case, the Rochin case. Now, more frequently, another case kind of popped up where the court considered the question of performing surgery on a suspect to obtain evidence. And this is in Winston versus Lee. Now, the case involved the recovery of a bullet that lodged in a suspect's arm when he was shot by the victim of the crime. And a search warrant or other court order, what was a necessary prerequisite to performing the operation without the person's permission. Okay, so he didn't want to give permission, so you had to get a search warrant. Now, although the court has not totally ruled out the use of surgery, it did establish kind of a balancing test. Surgical procedures that pose any threat to the suspect's health cannot be done. And the prosecution, in order to get some of these surgeries done, must show a compelling need for the evidence. Now, if there's another way that the information can be supplied, that would be another avenue that law enforcement would have to take as well. So here we're talking about a couple of different ways to, let's say, take evidence from individuals, methods of obtaining, if you will. So now what about, as it relates to force, the right to detain and using force in that? Well, I want to start with something that we called field interviews, and then we'll kind of move into this. So many times the police observe something that does not provide enough information to make an arrest, but indicates that, you know what, there's something occurring that needs to be checked out. And the U.S. Supreme Court agreed that officers should have the power to detain someone and ask them questions in these situations. And you would probably want somebody to do that too. If they saw somebody acting suspicious in your neighborhood, you would certainly want them to stop and detain them, because that's what officers should be doing. Now, the standard for a temporary detention can be found in a couple of different case laws, but the police may temporarily detain someone for questioning if there are specific articulable facts that would lead a reasonable police officer to believe that criminal activity is taking place. And the leading case that we'll get to in a minute is Terry versus Ohio. Well, what about that force in detaining people? Well, the standard to detain someone for a field interview is frequently called reasonable suspicion. And it differs from the standard for making an arrest in several ways. And the standard for arrest is what, everybody? Come on. Well, that would be probable cause. So I just want to make sure that everybody's kind of up to speed on that. So reasonable suspicion does not require as much evidence of wrongdoing as is needed to make an arrest. For a field interview, the officer must be able to cite specific facts, articulable facts, right, that support a belief that criminal activity is present, but it is not necessary to identify a specific crime believed to be in progress. Now, to make an arrest, the officer must believe that it is more probable than not that the suspect committed a specific crime, and an arrest is based on what a reasonable person would conclude. Okay? Temporary detention can be based on what a reasonable officer would believe. Now, in your textbook on page 357 is a comparison of field interview and arrest, and you can look at the reasonable suspicion versus probable cause, and there's two columns, and it kind of shows you the differences. Now, even though the court allowed the police to detain someone against his or her will without making an arrest, the police still can't stop people anytime they just feel like it. Now, an officer may stop someone based on reasonable suspicion, but not on mere suspicion or like a hunch, like, dude, the hair on the back of my neck is standing up, I got to stop this guy. The officer must have specific facts that can be stated to justify detention. And again, remember, that's sometimes called articulable suspicion. And the first officer arriving at the scene of the Trayvon Martin shooting did have reasonable suspicion to detain Zimmerman based on the 911 calls and what he personally observed when he arrived. So how long then can you keep somebody there? Well, the court has never set a specific time limit on temporary detentions, and the length of time must allow the officer to conduct a brief investigation. Now, how long that investigation may take might vary with the circumstances. One case involving a 90-minute detention was ruled unreasonably long, and cases involving 20-minute stops have been upheld. The detention should last no longer than is necessary to determine if the person stopped was actually involved in some type of crime. And the important thing is that the police diligently pursued reasonable investigative techniques in order to decide if this person should be arrested. And the courts have interpreted interpreted the temporary detention standard quite freely, permitting many police actions. So for detention, the use of force in detention of suspects, force used to effect an arrest, it's based on probable cause. We know that. We just went over that. And the crime and the victim and the total circumstances are important. And we know excessive force, we've talked about this, could result in criminal charges against the officer. And we didn't mention this, but it could also result in civil lawsuits as well. And we've already learned that, field interviews, this word, is basically where the police briefly detain a person to question them. And we've heard this phrase or this case law, a Terry stop. And this is where police with articulable suspicion of a crime can detain someone and question them briefly. And again, under the right to detain, we need reasonable suspicion of a crime, and it can't be that mere suspicion or some type of hunch. Well, here's the Terry versus Ohio case, and this is a big one, everybody. And even though it was back in 1968, and this has a lot to do with this stop and frisk thing. And if you Google stop and frisk New York PD, you'll get a lot of videos, and you can watch some of the controversies that are actually taking place over this type of stop. But here you go. So, police officer saw several men acting nervous in front of a store. Now, there's a lot more to it, and you can click on the links, but again, this is the brief overview. And the same police officer, McFadden, had years of investigative and street experience and believed that based on what he saw the men do, that they were casing a store to rob it. And because of that, McFadden stopped the three men, and patted them down and found weapons on two of them. And the court found that such stops, or what we call Terry stops now because of the case law up here, the court found that these Terry stops with pat downs for weapons, you know what? They were constitutional as long as it wasn't intrusive. And to add a little bit, the rationale for the pat down would have been what? To check the people for weapons, for officer safety. This officer didn't stick his hands in the person's pockets. He patted down the outer portions of their jackets. And then when he felt what he believed were firearms, then he retrieved them, and in fact they were. So that's the emphasis of the Terry versus Ohio case. And it's probably good to talk about this because recently police departments are using Terry stops to lower crime rates by arresting petty criminals after Terry stops. The stop and frisk, finding guns and dope and things like that. But should the Terry case become the basis of police policy? Should the right to search under Terry be expanded or perhaps more regulated? And what dangers would such expansion or regulation create? Do me a favor, if I didn't post a video in the introduction module of this particular chapter, go into your search engine, Google Terry versus Ohio, New York PD on YouTube, get a YouTube video and watch the debate over stop and frisk. You'll find it very, very interesting. So again, while we're staying with this standard of detention, we're talking about this temporary detention still. And we talked about the fact that there's really no time set. There's no set time there, but it needs to be more in minutes than hours. And we know that a 90-minute detention was ruled unreasonably long, but yet 20 minutes was okay. And these searches, remember, they're limited when we're talking about detentions. They're limited to pat downs, the outer clothing of somebody, which is called a frisk, for safety, for weapons. And you can't use evidence discovered to justify a search. Meaning that if you pat someone down and you find something, you can't, and maybe you stop them unlawfully, you can't go back. You can't reverse everything and say, well, hey, what I found justifies what I did. That definitely won't work, okay? So a little bit more and we'll move on. We talked briefly about how the courts have interpreted the temporary detention standard quite freely. And an example would be the Supreme Court held that the fact a person ran from the scene when a police officer approached would be sufficient grounds to detain that person for questioning, and that was the Illinois versus Wardlow case. And merely hanging out with other known criminals or loitering in a high crime area, you know what? That wasn't sufficient to justify a stop. Now remember, at the very beginning when we started, we talked about the three kinds of stops: consensual, the reasonable suspicion detention, and then the probable cause arrest and search. Now that consensual encounter, you don't need any legal standard to approach someone and talk to them. The issue becomes if you detain them, then you need a standard. If you don't and they're free to leave and you're just talking to them, then that is totally fine, and you're okay there. So hopefully that kind of you kind of get that. All right, I just want to make sure that I'm hitting all these areas. And now let's move into a couple of more issues relating to searches during temporary detentions, and then we'll move on. So the Supreme Court, recognizing that it is frequently necessary to search suspects in order to protect the officer, established standards governing these searches. And this limited search is frequently called the frisk or the pat down, and we mentioned that. And it is solely designed for the protection of the officer. Now there's no automatic right to search every person stopped. You can't just do that. Officers have to have reasonable suspicion that the search is needed for their protection, or they can consent to a search if they want to, and that would be okay as well. Now, if a person is stopped, for example, because there's reasonable suspicion that a violent crime has been committed or in progress, the right to search is, kind of logically follows. Now, if the situation involves a property crime, there may be little or no right to search. So the standard for search during a temporary detention is as follows, if you will. During a temporary detention, a search for weapons may be done if and only if the officer has a reasonable suspicion that the suspect is armed or dangerous. The officer may conduct a pat-down of the outer clothing, remember, for weapons. And if the officer feels an object believed to be a weapon, like in the case law, right, Terry versus Ohio, he can retrieve it or she can retrieve it, because based on your training and experience, what a weapon feels like. Now, the scope of the search is limited to what is necessary to protect the officers. And as previously said, in most cases, this involves patting down the suspect for weapons. And again, if officers feel something they believe is a weapon, they can retrieve it. And sometimes the search may be a little bit broader. So, for example, in Terry versus Ohio, the suspects were wearing heavy coats because it was a cold winter day. And in this case, the court approved the search for checking their pockets for items that could not be perhaps detected during a pat-down of the bulky nature of the coats. Now, if you look in your book on page 359, you'll see a diagram that talks about areas that you can search on a detention. So let's go a little bit further. So figure 12-1, which is on page 59 or 359, shows the extent of a legal search when a person is driving a car that was detained based on Terry versus Ohio, and there was reasonable suspicion that he was armed, the person in there, or that there was a weapon in the car. And it shows you the areas that you can search. So, like the passenger compartment of the vehicle, but not the trunk or under the hood. and you can search the person as well in order to locate weapons. So take a look at that diagram. Now, when police acting on reasonable suspicion retrieve what they believe is a weapon, it is a legal search. Now, if in fact the object they seize is not a weapon, whatever they seize will still be admissible. And this falls under what we call the plain view doctrine. And the right to retrieve items in this particular doctrine was expanded by a case called Minnesota versus Dickerson, where the court allowed officers to remove items that did not feel like weapons, but if by their distinctive feel, it could be determined the item was contraband. And this is called plain feel. Now look on page 360, and there's some examples of legal searches and illegal searches. So quickly, an example could be if I'm patting you down for weapons, but I pat, let's say, your pocket, and I've been working undercover narcotics before, and I know what a heroin balloon feels like. And as I pat your pocket down, I feel what I believe are those kind of rubbery, boingy, if you will, whatever, little round balls that feel like heroin balloons. And if I can articulate the fact that I believe these are heroin balloons, then I can actually arrest you and remove those items from your pocket. And that would fall under the plain feel area. Does that make sense? But again, we're going to go back to this thing called articulable. You have to be able to articulate. Okay, let's move on. Special situations. So we're still talking about standards for temporary detentions. Well, what about some special situations, some kind of different things? Well, a variety of situations have been before the Supreme Court, and you should be familiar with the rights of the police to act on each of them. So knowing what you're talking about, and when you can and when you can't search, and what you can and what you can't search, that's a great trait or knowledge base to have. And the first one would be the fact that, you know what, officers, they can request identification. Now, there's a myth out there that, you know, when officers stop you, that you don't have to show them ID. Well, if you're driving a car, you have to show them ID. It's the law. And there's no way to get around that. You have to have a driver's license to drive. So you can't use the excuse, well, I don't have to show you. Well, actually, yes, you do. Now, in other instances, okay, if there's reasonable suspicion to stop someone, the officers can demand that that person give the officers his or her name because you're conducting an investigation. Now, if it's a consensual encounter where you're walking up and you're just kind of hanging out and you walk by and go, hey, dude, what's your name? I don't have to tell you my name then because that's different. So I think we need to make sure that we know the laws here. And when it comes to cars, there's some other things that kind of take place. And car stops sometimes are more limited. And we'll talk a little bit about that. So the police do not have the right to randomly stop a car merely to check for like registration or to see if someone has a driver's license. But we can do, like there are some roadblocks and things that we can set up that are permissible. We can have a DUI checkpoint because that's found to be safety driven. And we can have an informational type checkpoint or roadblock to locate missing persons or to hand out information, if you will. And at the border, there can be, you know, border checkpoints, and those have been found to be valid. But you can't have like narcotics checkpoints. You can't just stop cars and search them for drugs. So let me kind of move on. So the most common situations for valid car stops really are violations of the vehicle code or reasonable suspicion for criminal activity. And at other times, the facts may indicate that there, again, is reasonable suspicion that the occupants of a car are involved in criminal activity. And then these cars can be stopped under the authority of Terry, that case, remember, to detain suspects temporarily, and the driver or the passengers in the vehicle may be frisked if, what? There's reasonable suspicion that they have weapons or present a danger. And officers have the authority to conduct a search of the passenger compartment for weapons only if there is what? Articulable and an objectively reasonable belief that the suspect is potentially dangerous and there are weapons in the vehicle. Now that right to look for weapons exists even if the officers decide to release the suspects. The rationale for this is that a suspect who has been released may return to the car, retrieve a weapon, and use it to harm the officers. Now, if you look on page 362, there are some examples of car stops, and there's legal car stops, and then some illegal car stops. So take a look at some of those as well. Let's see, we're still here. Well, what about fingerprinting? Well, the Supreme Court in Davis versus Mississippi and Hayes versus Florida heard cases involving taking suspects to the police station for fingerprinting. Now, both times the court ruled that this may not be done without probable cause to arrest. So I can't just snatch you up in the field because I think you're involved in something and take you to the station and fingerprint you. Now, but I can't arrest you in the field. And then as part of the booking process, when I take you to the station, I can take your fingerprints. Now, the most recent case indicated that it would, however, be legal to fingerprint a person at the scene. Now, remember, a lot of times we have these portable fingerprint machines in law enforcement. There's a lot of new and cool technology. So there are instances where we could, take your fingerprint in the field under utilizing one of those machines, or actually even fingerprinting you in the field. But we can't compel you to do that, unless you are under arrest. So examples of fingerprinting are on page 363. Well, what about interrogations? Well, Miranda warnings are not required when an officer questions a suspect during a temporary detention based on reasonable suspicion. Now, the warning will be required for questioning after an arrest is made and you're going to be interrogated. So for Miranda, there really has to be two factors present: custody and interrogation. Now, if this is just a temporary detention and I'm investigating a crime, I don't have to Mirandize you because there's no custody. Does that make sense? So there are some examples on page 363. What about school searches? Well, students have fewer rights to privacy than the public, and searches by school staff have fewer restrictions than by police. Now, special needs of schools to maintain a safe environment and what they call loco parentis, and I'll tell you what that is perhaps in a moment, rights, give the school a little bit more power, if that kind of makes any sense. So searches by school officials are governed by standards similar to those that apply to, let's say, temporary detentions. And again, there must be reasonable suspicion that the student has broken the law or violated a school regulation. But school searches, they're not restricted on the use of weapons either. So there are a couple of different aspects that relate to school searches. Well, how about canine searches? Well, the Supreme Court has allowed customs agents to briefly detain luggage in order to have narcotics detection dogs check it for drugs. And the case United States versus Place held that there must be reasonable suspicion that the suitcase contained drugs. Now, the luggage may not be opened prior to the canine search, which makes sense. And additionally, the detention must not be unreasonably long. Now, the fact that a reliable, properly trained dog indicates drugs are present establishes probable cause. And that's what you need, of course, in order to arrest and search, right? Remember, we talked about that. And so drug sniffing dogs may also be used during routine traffic stops as long as they do is indicate the location of the contraband substances. And they may go any place that an officer would legally have access to go. So here's an illegal canine search. A car suspected of being used to smuggle narcotics into the United States is stopped in the desert for an hour while the officers wait for a dog trained to sniff out the narcotics to arrive. You can see how that would be unduly long, etc. So look on page 364 for some examples. So what about arrests? So now we've talked about all the other detention stuff. So let's try to get through the arrest section in a hopefully a reasonable amount of time. God, and we've used that word so much. So in Fourth Amendment terms, an arrest is the seizure of a person, and more commonly, it is thought of as taking a person into custody for committing a crime. Now all arrests must be based on what? Everybody, come on. Well, you're looking at it right there. Probable cause. And officers do not need to personally evaluate probable cause for the arrest if they are executing an arrest warrant or acting at the discretion of another officer. And I'll explain that a little bit more. Now, there's a table in your textbook, and let me see if I can find it. Here it is. On page 370, that compares the field interview that we've discussed in the previous section with an arrest. So you could look there and you can kind of see the differences. So arrests are seizures and must have probable cause, which is beyond mere suspicion. And we need to show probable cause for each element of the crime. And we'll talk about Miranda in just a second. So let me keep going with probable cause to arrest. So probable cause consists of a group of facts that make a reasonable person more certain than not that an event occurred. And in an arrest situation, that reasonable person must be more certain than not that the person arrested committed a specific crime. Now, again, this requires a higher level of certainty than reasonable suspicion needed for the investigative stop, okay? Now, to decide if there is probable cause, the officer has to determine that there is probable cause for each element of the crime. And in many cases, an arrest is made for one crime, but different charges are filed by the prosecutor. And this may be due to new evidence, like drugs that are found when the suspect was searched after he was arrested. And it can also be due to information discovered by police between the time of arrest and, let's say, when the charges were filed. Now, after the arrest, remember, if the police question the person, they have to Mirandize them. But just because they arrest them does not mean that they have to Mirandize them. And think about it. We don't do a lot of Mirandized interviews in the field. We take the people back to the station, place them in a controlled environment where we can video and audio tape the interview, etc. But remember, in order for Miranda to apply, custody and interrogation, both of those pieces need to be present. So the arrest that we've been talking about is still valid if At the time of the arrest, the officer had probable cause to believe that the suspect committed the crime for which he or she was arrested. So here are what we call powers of arrest. And this might seem a little bit confusing, but I'm going to try to make this as simple as I can. So these are police officer powers. Now, at common law and in many states today, an officer may arrest without an arrest warrant if there is probable cause to believe that a felony has been committed. And unless the state legislature has changed the traditional rule for misdemeanors, officers are typically required to have probable cause to arrest, but can do so without a warrant only if the crime is committed in their presence. Now, there's a couple of times there's a couple of instances where that has actually changed. And when the crime has occurred before the officer arrived at the scene, the arrest must be made by someone who witnessed it, or the facts must be presented to a judge who can issue a warrant. Now, that was for misdemeanors. So here, I'm going to try to unravel the confusion here. A peace officer may arrest a person in obedience to a warrant. Okay, we know that. Or pursuant to the authority granted to him or her without a warrant under any of the circumstances that I'm going to talk about right now. 1, the officer has probable cause to believe the person to be arrested has committed a public offense in the officer's presence, and that's a misdemeanor and a felony, public offense. Okay? So if it happens in front of me, I can do it. I can make the arrest, right? Well, look at number 2. The person arrested has committed a felony. Now, it doesn't say misdemeanor. It says felony, although not in my presence. Well, geez, what does that mean? Well, how about if somebody robs a liquor store and you get a description of the car, let's say, and half hour later you find the car parked in a parking lot, so you pull up behind it to investigate, you walk up, and it turns out that this guy's the robber. Did the robbery happen in your presence? Like it says here in number 1? No, it didn't. But it tells us in the code the person arrested has committed a felony even though it didn't happen in the officer's presence. You can still make an arrest. And then finally, the third one, and this one is even a little bit more confusing, so hang with me. The officer has probable cause to believe that the person to be arrested has committed a felony, well, whether or not a felony was in fact committed. So it doesn't even actually have to have been committed, but if you have probable cause to believe the person to be arrested has committed the felony, you can go ahead and make the arrest. Example could be, perhaps you believe you stop someone, they have a ski mask, a bag full of money, a gun, but you don't have a victim of a crime yet. And you talk to the guy and maybe he admits to, he gives you some wazoo story. Now, if you have probable cause to believe that he committed a robbery, that's a felony. Okay, and it wasn't in your presence, but you have probable cause to believe he did, you could book him on that. Now, you're still going to have to locate a victim to get that case filed. But let's just say that maybe it turns out his excuse was true and there was no robbery, but didn't you have probable cause to arrest him in the first place? Well, yes, you did. Therefore, Section 3 is applicable. I know, it's a little bit confusing. And here's the case of Miranda versus Arizona when we talk about Miranda. And this is another one of those Supreme Court precedent cases. Now, Miranda was arrested and brought into police custody. And the police didn't inform Miranda that he could refuse to talk. They didn't tell him, hey, dude, you don't have to incriminate yourself. Or you can have an attorney if you want one. And you know what? We'll pay for it. And because of that, because these rights weren't told to Miranda, therefore he wasn't afforded those rights, the Supreme Court ruled that suspects after arrest who are undergoing questioning, they have to be made aware of their basic constitutional rights, and that would be these. The right to remain silent. I don't have to say anything. the right to an attorney, and the right to have an attorney at state expense. Watch this video. It's pretty cool. Got a lot of good information on the Miranda case. So because we're over in time, we're going to move on. So again, we talked about powers of arrest. I kind of went through that one slide. So police, we need probable cause to arrest for a felony if done without a warrant. For misdemeanors, a little different. You need a warrant or the crime should have been committed in your presence. Now there's a couple of instances, and one I'll touch on without trying to confuse you. For the most part, yes, misdemeanors have to occur in our presence, or we're going to have to long form a case to the DA and get a warrant, or someone can make a private person's arrest or a citizen's arrest, etc. But DUI is one case where there's a presumption there. So, and it, you know, if you pull up to a red light and someone's asleep behind a car, they're passed out behind the wheel, and they've been drinking, and they're in the middle of the intersection, you can assume that they were driving while intoxicated. Now, while you didn't see them driving, that really doesn't matter in that case of DUI. And again, not trying to confuse you, but that's just, I want to let you know that there are a couple of exceptions. Well, what about citizens? Well, some states allow citizens to make arrests, and we'll just leave it at that. And a warrant allows an arrest in any situation that after the judge signs it, of course. And warrants are always, of course, preferable for home arrests, because a home is somebody's castle, and therefore the court has said time and time again that they would prefer that the officers get an arrest warrant. So officers are required to obtain a warrant if the arrest is to be made in a home. And either an arrest or a search warrant can be used to enter a suspect's home to arrest him or her. And a search warrant is needed if the officers must enter any other home to make an arrest. And that's actually, there's a special name for that case. It's called a Stiegel warrant, and it's based on the case Stiegel versus United States. And the foundation for this rule is that, of course, the right of the people to privacy in their homes. So we talked a little bit about searches. Let's talk about search incident to a lawful arrest, and we're getting close. And again, I apologize for going over, but we got to get this info in. So the current rule on search incident to arrest was established in a case called Chamel versus California back in 1969. And that case justified the search based on three factors. One, protection of the officer. Two, prevention of destruction of evidence of the crime. And three, the seizure of contraband. And it allows officers to thoroughly search a person and the area under that person's immediate control of the person being arrested. So the older rationale for search after arrest was to protect the police from harm, to prevent destruction of evidence, and allow seizure of contraband. But a new standard also adds the limited search to the area under the suspect's control. And the crime the suspect was arrested for has no bearing on the extent of the search incident to arrest. And I'm not going to give you all the case laws on that. And even for offenses that have no physical evidence, like driving without a license, the search may include the person, an area under his or her immediate control if the person is arrested and taken into custody. Now, the rule applies to all crimes for which the legislature has given an officer authority to take someone into custody, even minor ones like driving without a seatbelt in some cases. Now, the justification for the search is the arrest. Okay, let's remember that. Therefore, items found during the search cannot be used as a basis for the arrest. So you can't find stuff and then use it to justify your arrest. It has to be the other way around. It's the arrest first, and then you find stuff. Does that kind of clear things up? Now, the search must also be done contemporaneous with the arrest. And only searches done at the scene immediately afterwards or after the arrest qualify. Those done later must be justified by some other means. Now, unlike protective searches done during field interviews, there are no restrictions on the thoroughness of the search conducted when the suspect is arrested and taken into custody. Only the area search is restricted. So only the area searched is restricted, and anywhere the person arrested could reach to obtain weapons or destroy evidence can be searched. And this is kind of what they call the arm's reach rule, or within their wingspan. And this is applied without considering the fact that the suspect was handcuffed prior to the search. So again, a lot of technical stuff. And anywhere he or she could reach, if not restrained, is included. Now, some courts have permitted searches up to 10 feet from the suspect. Others are not restricted to places where evidence is believed to be. They may open drawers, look under sofa cushions, check in clothes dryer, or check anything else provided it's within the arm's reach. Now, again, a lot of different variables from state to state. Now, we're looking at a picture that kind of shows you where you might be able to search or not based on incident to arrest. So a good diagram here. So if you look, and let's say this person is taken into custody, well, we can search them, right? And it tells you right here. Now, this is considered like within arm's reach. So we can search the couch and the cushions and this table that's right here, or maybe the little side table drawer. But we can't go all the way to the kitchen, and we can't go all the way to the closet. Is this kind of making sense? So this diagram, again, helps add a little bit of context to this search incident to arrest. Now, whether or not a physical arrest is made is pretty important. When the state law authorizes a custodial arrest, it shows the offense is considered sufficiently serious to justify a major invasion of somebody's privacy. And if the state deems the action less offensive, officers may be authorized to cite and release the suspect on the spot. Now, obviously, a citation, like a ticket, is a much smaller invasion of the suspect's privacy. So when we pull you over for a detention and write you a ticket, are we allowed to search you? Well, no, because what do you need to search? You need probable cause or consent, or if we arrest you because we have probable cause, that changes things. But if we write you a ticket, we don't have that cause to search. Now, accordingly, intrusive searches are not permitted, and we talked about it. Traffic stops are a typical example here. Now, if the suspect is released at the scene, the officers may not invade the suspect's privacy by doing a thorough search. Now, one thing we can do on stops, though, officers can, however, order occupants to get out of a car. And the right to search in these situations is similar to what can be done during a field interview, like a pat-down for weapons. But again, it's only allowed if there is reasonable suspicion the person is armed. And due to the fact that officers are only with the offender briefly, their need to protect themselves is not the same as when the offender is taken into custody. So a little bit more, and we're going to talk about cars, I think, and then we'll be getting close. So in Arizona versus Gant, the Supreme Court allowed searches of vehicles incident to arrest of the driver or the passenger under limited circumstances. The same rules apply if a person was arrested outside of a vehicle he or she was in when the officer approached. Now searches are now permitted only if there is reason to believe that the arrestee might have access to the vehicle at the time of the search, or that the vehicle contains evidence relevant to the offense for which the person was just arrested. I know that's a mouthful. Now, assuming one of these reasons applies, an extensive search of anything in the passenger compartment, including luggage and other parcels, may be done immediately after an arrest. And under this rule, the vehicle may not be towed to an impound lot before the search is conducted. And when an arrest is made in a home or other building, officers do have the right to do what they call a protective sweep. And this sweep is a quick visual check for people hiding nearby. And at the time of an arrest, and without additional facts indicating any dangers, officers can look in the immediate adjoining areas where the arrest was made, such as a bedroom or something really close where somebody could hide. Now, smaller areas, of course, dresser drawers and things like that, we can't look in. And this is sometimes called a Bowie sweep, and it's based on the case Maryland versus Bowie. So we won't take the time to go over the Chamel case, but I talked to you about that. This is the arm's reach case where police were, arresting a party in their home, and incident to the arrest, the police searched the home. And the Supreme Court basically said, hey, the officers could only search the petitioner's person and that area from within which he might have access to obtain a weapon or something that could have been used as evidence against him. So a couple of other things, and then we'll be done. So search of the individual. Remember, area immediately under control for weapons and contraband, and it's irrelevant. It doesn't matter what the crime is. Justification, we can't use items found to justify the arrest. Arrest versus field search. Well, arrest searches can be more intrusive than a frisk, because remember, the frisk is typically the outer clothing. And then under discovered evidence, whatever is found is admissible, even if it's not related to the arrest. And we talked about physical arrest versus citation. Well, just a ticket, offense, search may not be limited. And this is usually controlled by state statute. And under vehicle search, yes, we can search the whole compartment if the arrest is for the driver or passenger, and it can be a little bit intrusive. And we talked about protective sweeps, that quick visual check of a larger area for safety. That is permissible. And then finally, booking. Well, booking is the process of admitting an arrestee to jail. And booking searches are designed to prevent entry of weapons or contraband. And they are limited to persons and property, of course. And in some cases, they can be extensive. There are policies on strip searches and things like that. And the court has held that these are okay. Now, typically, strip searches, sometimes you may have to actually get a search warrant. So, there are a couple of different issues that might come up here as it relates to, let's say, strip searches. And there may be some limits, of course, for minor offenses. And when it comes to the suspect's property, anything that an arrestee possesses is subject to search if they've been arrested, and now we're doing the booking process. So any closed container you can look in, because it doesn't fall under that closed container rule. You can look in that because you're inventorying and going through all of the property, etc. And then the last thing, jail and prison searches. Well, once a person has been booked, his or her expectation of privacy is reduced greatly. In fact, it kind of disappears. And the Supreme Court generally allows jail searches if a valid administrative reason can be given. But once in physical confinement, virtually any searches are permissible. And searches, again, are based on that administrative reason. And when it comes to searching of persons and the cell, individuals may be extensively searched, and there is no expectation of privacy in a cell. It's open to any warrantless search. Okay, so that's it for this chapter. And I know that was a lot a lot to cover. Go back through and look at some of the examples that they give you that are underneath some of those big subject areas that we talked about. So this will conclude our chapter 12 lecture. If you have any questions, post them on the discussion board. And if you don't want to post them there, feel free to email me. And if there's nothing else, until next time.